Professional liability insurance is typically obtained by professionals, by businesses, by small businesses mostly. And these policies pay for professional liability claims. In other words, when you are doing your job and somebody asserts that you haven't done it correctly, that you might have been negligent in the way that you handled a claim, or a doctor that mishandled a surgery, or an architect that may have missed something on some plans and didn't get it right, and somebody now wants to sue them, these policies provide coverage for what is called the right of indemnity and the duty to defend. So if you get sued in a lawsuit, you tender to the insurance company, they will defend you in a lawsuit if there's litigation, so they'll pay all of your defense costs. And in addition, if there's a judgment or a settlement, they'll pay that. So that's how these policies work. They pay for defense of a lawsuit and the liability on the lawsuit for professionals who have this type of insurance. Professional liability insurance companies deny professional liability claims more than you would think, and probably I would say frequently. There are various grounds that they do so, but one of the main reasons is that they don't give appropriate notice of the claim, because these are known as claims made policies. So when a claim is known to an insured, they have to now immediately notify the insurance company. And if they don't do it right away, the insurance company may take the position that the claim is not going to be payable because they didn't notify the company right away. And this can get hugely complicated, especially with respect to professional liability claims. It is really important to make sure that you file the claim as early as possible. The issue becomes, what is a claim? What is the type of situation that I now need to tell my insurance company about? Maybe some client has made a complaint of some type, but it doesn't sound that serious. You believe as a professional that you didn't do anything wrong, but it's not really that serious, it seems to you. You may not decide to tender that to the insurance company, in part because you don't want your insurance rates to go up, and maybe if you tender that claim, they might raise your insurance rates. So in these types of cases, it's very important to decipher whether or not you need to make a claim. And a lot of times that issue alone is the reason you should come to a law firm like ours, because we can tell you whether or not it's the type of claim we think that you should have tendered or should tender, because if you don't, there are going to be ramifications to you that are negative. If you've already made the claim and the insurance company has denied the claim for some other reason, then we can get involved and we can handle that claim, and we can do coverage opinion letters, we can prosecute a bad faith case, we can do whatever needs to be done to prosecute that claim and to make sure that the rights of our clients are protected. I have been handling professional liability cases for many years. I would say that I first handled them probably over 20 years ago. And I was doing that on the defense side, where insurance companies would hire me to give them coverage opinions about whether or not claims should be paid and whether or not claims were appropriately made in the policy period. Since then, on the plaintiff side, on the policyholder side, I have represented a number of professionals and businesses who have come to us to get good advice from experienced lawyers. And because we have been doing this for a long time, our firm is a good firm to come to. When a client communicates with us, either by email or telephone, it is very important for us to get back to them. We understand that they're nervous about their cases, they have questions. We're there to answer those questions, and we do it well and we do it quickly. So I pride myself and my firm on our ability to get back to people. Our standard is to try to get back to everyone within 24 hours of the date of the email or the phone call. Communication is essential between our clients and ourselves, and so we strive to make that a very important part of our representation. We are a small firm, and because we're a small firm, we're agile. We can make sure that we get things done quickly. We don't have levels of regulatory detail to go through with bigger firms. A lot of times, if you have a decision that needs to be made on a case, or whether to take a client, it has to go through a panel, it has to go through higher ups at the law firm. I make those decisions, I make them right away. And because I don't have to answer to anyone else, I can take more risks if I need to on behalf of my clients. And that will inure to their benefit because we normally will get a better result. When you hire my firm, I stay involved with your case. I stay involved with every case in the law firm. However, what I do is I will give the case for day-to-day handling to one of my attorneys. However, I'm there all the time. I'm able to answer any questions that you have. I am able to make sure that everything is done well. I supervise all of my cases and all of my attorneys. When you come to us initially, we're going to have a discussion that's going to begin the intake process, the evaluation process. We're going to talk about whether or not we think you have a good claim. We're going to, for example, decipher whether or not you need to file a claim at all. If you already have filed a claim and the company has denied the claim, what part of the claim have they denied? Have they denied the duty to defend? Have they denied the duty to indemnify? Depending on what the answer is, we're going to get the information we need and we're going to prosecute that part of the case that needs to be prosecuted.